So good evening, Uganda. This is 2025 January. We are starting from where we ended last year with Council Tobias. But today we are discussing the issue of continued trial of civilians in the military general court martial. And we know that we still have Council Kiza Aaron, who was illegally sentenced to 9 months in prison. So Council, maybe you tell the people a Happy New Year, as me have told them Happy New Year.
Okay, now good evening to everyone. Happy New Year. It's a year of struggle. The way we started it, I'm Council Tobias, and I'm here to engage with you on whatever has been happening. A lot has happened, but I'm sure by the end of this episode we shall have discussed much of it. Okay, thank you.
So, Council, we are going to start with the general court martial in Uganda. We saw a lot of exchange between the lawyers of Dr. Kiza Besigye, of which you're part of them. You people were having a lot of bitter exchange in the general court martial with the team from the general court martial side, and your argument was that this is not a military court, or it's not a competent court, it's rather a military tribunal. Maybe we start from there. What's a tribunal and what's a court, such that we know what we are dealing with here?
So, defining a court, if you look at Article 129 of the Constitution of Uganda, it clearly outlines what constitutes, which courts are called, fall under the courts of judicature. It tells you courts of judicature include High Court, Court of Appeal, Supreme Court, and other subordinate courts. Now, these courts can include maybe magistrate courts, but a tribunals are legally constituted. Now, for the case of the court martial at Makinde, it's a tribunal and not a court. Although they have failed to get the definition of it, to accept it, but it falls under a tribunal.
Let's first get the definition of a tribunal.
Now, let's get a definition of a tribunal. A tribunal is defined as a judicial body that has power to make decisions on disputes or claims. Tribunals are similar to courts and often have public hearings and are independent from the government and are required to make decisions based on law. So the general court martial is a tribunal, and not a court.
Let's also get a definition.
Now let's get a definition of a court. A court can be defined. A court can be defined I'm trying to get the definitions in Black's law. A court is defined as a body of people presided over by a judge, judges, or a magistrate, acting as a tribunal in civil and criminal cases. Are you getting the definition?
Let me first ask. I've heard in a court you're saying that it's headed by a judge, judges, or magistrates.
That's the Black's law.
Yes, but now when you people were in the general court martial, I was hearing you people referring to the person heading there as chairman, Mr. Chairman, sir. Mr. Chairman.
Actually, that's why we are trying to differentiate between a court and a tribunal. The Black's law dictionary is defining a court as a body of people presided over by a judge, judges, or magistrates. Now, if the court martial is being presided over by a chairman as its head making decisions, and Black Soil Dictionary is not even considering it as a court. So I think it falls under tribunal, as we earlier discussed it. Yes.
So another question is, the people that we saw in the court martial, are they lawyers? Did they do law in any level from the chairman up to the rest? Because I saw there was the team that is headed by the chairman. Then we saw the one whose work is to advise the general court martial. I don't know how he is called, but the one whose work is to give them legal advice. I don't know whether he also did law at any level. So did any of those people do law at any level?
Now, the general court martial, let me call it a tribunal, yes, or kangaroo court, although they try to change the meaning, it has land friends. These include the judge advocate. Now, if you read the PDF Act, it tells you the role of the judge advocate is to advise court. The whole panel in the court martial is not, they're not legal personnel, they're appointed judges.
They didn't do law at any level.
Yes, they're just appointed to give decisions based on the advice of the judge advocate. And maybe the prosecution, those might have learned some law, because they are prosecutors, those are land friends. But the only person who is learned is the judge advocate.
Whose work is to advise.
Yes, whose work is to advise, just to advise, but not to make final decisions. The general court martial.
I understand.
Yes.
So I think we have a clear picture of the general court martial. We are talking about the one of Uganda. That it's headed by a chairman who didn't do law at any level with all the rest of the people in the panel. They didn't do law at any level, but they have a judge advocate whose work is to advise, to give legal advice to these people of the panel. His work is not to make legal decisions or any conclusions. Though we saw him trying to make assertive exchange with the teams of Dr. Kiza Besigye, as though he was trying to give them commands, and they were trying to tell him your work is to advise, not to make rulings here. So I think that's a clear picture of the General Court Martial of Uganda. First of all, it's not headed by a judge, which disqualifies it from being a court. Therefore, it's a tribunal according to the definitions. So let's go to the case of Kiza Aaron. Kiza Aaron has been our friend. He's our friend. He has stood for so many people in court, irrespective of their political affiliations. He's a human rights champion. I think that is where most of us have met him. He was sentenced by the General Court Martial of Uganda. So I should simply call it a military tribunal of Uganda. And he was given 9 months in prison. And the crime was the contempt of court. So my question here is, since we have given the definitions, and we have seen that the other one is not actually a court, it's a military tribunal, does this offense then stand? Can someone commit contempt of court in a tribunal?
That's where the challenge comes in. That's what I've told you, it's a tribunal. The course of judicature, actually I wanted to read for you verbally here what constitutes, which ones are called courts of judicature under the constitution. Because remember, Article 1 told you the constitution is the grand norm, like the fundamental law. So let's read let me read for you Article 129 of the Constitution. Yes. Article 129 of the Constitution of Uganda talks about the courts of judicature. The judicial power of Uganda shall be exercised by the courts of judicature, which shall consist of the Supreme Court of Uganda, the Court of Appeal of Uganda, the High Court of Uganda, and such subordinate courts as Parliament may by law establish, including Kadi courts, divorce courts, inheritance courts, guardians, these are family courts, and Supreme Court, Court of Appeal, and these other courts of record. We need to talk about the court martial in any instance. But legally, tribunals are legal decision makers and recognized under the law. It's not wrong to call them tribunals, calling a court martial tribunal, but it's not a court of record. It's not a court of record. So I think charging Counsel Aaron for contempt of court was wrong in the first instance. It's a wrong decision. That's why we are appealing against it. We have gone to the Constitutional Court. We have gone to the Court Martial, Court of Appeal, because first of all, the decision itself didn't have the law under which it's brought, and even the offense itself has a different conviction. Yes, in the court.
That is where his case stands. Now, supposing he had actually committed an offense of contempt of court, was that sentence fair? Because we have seen that it was a wrong decision, meaning it is legally wrong, and there's an appeal. Supposing he had committed, was the 9 months fair, legal, within the UPDF Act?
Now, first of all, before we even go to whether the punishment was fair, Article 28 talks of a fair hearing. First of all, Counsel Aaron is not, let's say he wasn't the accused.
Yes.
He was the advocate in the case. And his arrest was not legal. First of all, because he was on duty. It was his duty to act for the client. Now, if you read the UPDF Act, Section 171, I wanted you to read for me. Let me give it to you. UPDF Act. Section yes, you read Section 171. It's Section 171 too. It's here. I'll get it.
Yes.
I've got it. Okay, it tells you. Let me read it. So, Section 171. Okay, can read for us. Section 171, 1 and 2. You can read the whole of it.
Yes, sir. So, offense in respect of military courts. A person who, being duly summoned or ordered to attend as a witness before a military court, makes default in attending. B. Refuses to take an oath or make a solemn affirmation lawfully required by a military court to be taken or made. I continue. Refuses to produce any document in his or her power or control lawfully required by a military court to be produced by him or her. D. Refuses to answer, when a military witness, any question to which a military court lawfully requires an answer. E. Uses insulting or threatening language before or causes any interruption or disturbance in the proceedings of a military court. Then F. Commits or omits to perform any act before a military court, which if done or made before a civil court would constitute a contempt of that court. Or G. Being an advocate conducts himself or herself in the manner described in subsection 9 of section 214, commits an offence and is on conviction liable to imprisonment not exceeding 5 years. I continue. This is now 2.
Put two.
Where an offence under this section is committed at or in relation to court martial, that court martial may, by an order signed by a member of that court, order that the offender shall undergo a term of imprisonment or detention for a period not exceeding 30 days.
Yes. 30 days.
So 30 days.
Okay, I've seen the maximum for contempt is where an offense is under this section is committed at or in relation to court martial. Court martial. The court martial may, by an order signed by a member of that court, order that the offender shall undergo a term of imprisonment or detention for a period not exceeding 30 days. I remember I looked at where they said this one of G, which talked of 5 years. So which people fall under 5 years? Let's look at section 135. 135. 136. Insubordinate behavior. You know, when you read the law, you read it as a whole. You keep connecting them. So, a person, this one talks about insubordinate behavior. A person subject to military law who uses threatening or insulting language to or behaves with contempt towards a superior officer commits an offense and is in conviction liable to imprisonment not exceeding 5 years. So these are people who are already in the forces. They are subject, they have superiors. It talks of a person subject to military law who uses threatening or insulting language or behaves in contempt towards a superior officer. This was an advocate. Yes, not a superior. This was an advocate and not a person in the military.
Not in the military.
Maybe you can take for instance, maybe the prosecutors who are already in the army and are maybe acting in contempt towards superior officers. These are the ones who can fall under this one. But for this one, contempt clearly states 30 days and not much.
I'm glad. Me matter. So that means now the other thing is the sentence given to him was wrong. It was illegal.
Illegal, and we are going to appeal it.
It was wrong. It was illegal. That means everything was wrong. Everything from the start was wrong because I recall that day. Council Kiza Aaron had just entered and was going to where to sit. That's when they grabbed him. And then he first took him out, is it for some 30 minutes? Then he was later on brought in to join his own client in the dock. Then later on sentenced to 9 months. Did they even read to him his crime? Like, everything was wrong about it. Everything was wrong. Everything was illegal. This was an advocate who had gone to do his duties. So maybe the message that we pick from there is that anyone who goes to the military court can at any one point be sent. You can be restrained. You can actually be sentenced. Or it's a way of suppression or to create fear among the lawyers of Dr. Kiza Besigye. I don't know. So let's go to the next thing. We said Council Kiza Aaron wasn't given a fair hearing according to Article 28. According to Article 28, and before that we have seen everything was wrong about it. So shall we read it?
So Article 2. Okay. So Article 28 is basically about what constitutes a fair hearing. Now, Article 28, let me read it. Article 28 talks about fair hearing, the right to a fair hearing. Article 28, Clause 1. In the determination of civil rights and obligations, or in any criminal charge, a person shall be entitled to a fair, speedy, public hearing before an independent and impartial court or tribunal established by law. I've talked of tribunals. Nothing in this clause or this article shall prevent the court or tribunal from excluding the press or the public from any proceeding. Clause 3 says, every person who is charged with a criminal offense shall be presumed innocent until proven guilty. Clearly telling you that by the mere arrest of Aaron, taking him to the cells and giving him a conviction without a fair hearing was so unfair and contrary to the Constitution. It also tells you the person shall be informed immediately in a language the person understands the nature of the offense. At least if they're saying it's contempt of court, they would tell him you have committed contempt of court. Not just bring him to the dock and telling him because of your conduct we have sentenced you summarily like that. We were not given a chance to represent him. We were not given a chance for him to even give a plea whether he's guilty or not. We were not given a chance to a fair hearing. First of all, the court didn't even consider what is the maximum sentence given for such contempt of court as provided for by the APDF Act. So clearly, his hearing and conviction was so wrong in all matters of the sense.
I actually saw the leader of opposition, Joel Senyonyi, saying the way everything happened is like everything was pre-planned, predetermined. Because as they were reading, they were citing things that happened in the previous sitting. So it's like they came pre-planned, premeditated, that this man has to be sentenced. That's what I had the leader of opposition say, that everything appeared to have been pre-planned. So, for those who can still, Council Kiza Aaron is at Chitalia. Take time, you go and visit him. You talk to him, you see him. And we were so encouraged. The last time we went there, we found a lot of people. Actually, the book where people sign when you go to Chitalia, almost everyone who had been going that week had gone to see Council Kiza Aaron. That shows you the influence he has. It shows you how much he has been into the fight for freedom, justice, and human rights. The whole book was full of people who had gone to see Council Kiza Aaron. The line was so long. We were unable to see him. We are actually planning to go back this week, and we meet him. So we are going very early, very early. So as we are going to check on Council Kiza Aaron, remember that we still have Dr. Kiza Besigye in the same military tribunal. We still have political prisoners of NUP who have spent there 4 years, others going to 5. We still have Machete in detention, remand under military tribunal or military court as they love to be called. We still have supporters of NUP who are still in that same military tribunal being tried illegally. So with that, we have the Supreme Court has come out to give a date that on 31st of January this month, they will give a ruling of the it's called Kabziguruka, about his case. Yes, yeah. So 31st January will give us the determinant of whether civilians will continue to be tried in the military court or that will be the end. And it will also give us, because we have the hashtag that is ongoing of judiciary on trial. So that will give us a clear picture of whether the judiciary has actually passed the trial or the judiciary has failed the trial, because they have been sitting an exam. They have read exams. They had time to read through the examination paper. 2020, 2021, they had the NUP political prisoners for a long time. People have been fighting, they have been sitting the exam, and they want to give us the result of their sitting. And we see whether the judiciary has passed the test or the judiciary has actually failed the test. We shall know that on 31st January. So 31st January, I call all Ugandans to be present at the Supreme Court as early as 7, because I understand their ruling will be at 9 a.m. So we can be there all as early as possible to witness what the judiciary has for Uganda. Whether they will undress themselves or they will come out in a clean suit. Justice Owiny Dolo, that is up to you to decide what the future people will say about the current justice system of Uganda. So, I don't know what we should expect for that 31st January ruling, but before we go there, at least we have things that can make us predict what might come out. We don't care about the outcome because there has been push for the Supreme Court to stop sitting on that ruling. Because so many people are rotting in the military court. We have seen the group of Olivia Lutaya. We have been calling out for their release for so long. And then they were finally pressured to accept crimes through the same military court. They came out and told us they were actually forced to do that. You either plead guilty or rot in jail. So those are things that can make us predict what might come out. Then I need us to remember that towards the election of 2021 in the areas of Karamoji, it was towards and during election. So many youth were arrested, abducted. Some reporters had it that up to 18,000 youth were arrested. And they were arrested, court-martialed, and sent to Chitalia to prison. Now, it is until last year when the president, General Museveni, was doing his countrywide tour. When he reached Karamoja sub-region, the elders asked him that, "Sir, our children, our youth that you arrested and court-martialed," he admitted in a very surprising way. He actually said he is surprised that he was still having these people, because those people were arrested with issues that were involving, is it cattle rustling? Because if you recall, what happened is when they brought the issues of cattle rustling, youth were abducted. It didn't matter whether you're at your work, people were at their work, others were working in restaurants serving food, others were in petrol stations as those attendants, others were at their own jobs. People were arrested, put in the pitch, sent to court martial. Court martial doesn't delay with them, it automatically sentenced them into prison. So last year, as General Museveni was moving around doing his countrywide tour, he promised those people of Karamoja sub-region, he actually admitted that he knows of about 900 something youth. Those are youth of our ages, very productive age, that shouldn't be in prison. So he admitted that he actually has them, but he will ask the team there to review those people's cases. Those who do not pose a threat to the community and the country should be released. I think you get the picture of our state of judiciary. So then we have another Supreme Court ruling that came out last year. And the ruling was more of the judges giving us suggestions. They didn't actually come out with clear rulings and orders, in my opinion. And was about the case of the second lieutenant, that is Ambrose Ogwang, who robbed the shop at gunpoint. What I remember is one they said the military court was right to try him, which is true because he was still a serving member. But they ruled, one thing that surprised the whole country is that they said the Court of Appeal has no jurisdiction over an appeal from the court martial, appeal court, which most of us saw as though they are giving the general court martial a total independence, total power, and their ruling appeared to say that the general court martial is parallel to the to the civilian court, to other courts. that it has the right to do everything that it can do, and then no one has a right to appeal in any other civilian court. That's what the country picked. And then a day or a few hours later, General Museveni came out with letters, as he always posts on X, praising that decision, and giving us how the General Court Martial has always been very fast in sentencing civilians and how it has been so helpful in eliminating criminals from the community. So with that history, what do we expect on 31st January from the Supreme Court in your own view?
Actually, to me, that was the decision in Ogwang versus Uganda. Now, first of all, what we need to know about the case of Ogwang is Ogwang was a serving officer who used this gun to rob a shop. The brief facts of the case. Uh, he robbed a shop and shot someone dead. So his case came up, the General Court Martial, and he was sentenced to, I think, is it death or something? Now he appealed to the Court of Appeal, from the Court Martial to the Court of Appeal. The Court of Appeal upheld the conviction. He appealed to the Supreme Court. So the Supreme Court comes up with the decision saying they don't have jurisdiction to handle appeals from the General Court Martial Court of Appeal, meaning that they're leaving room, meaning that the General Court Martial Court of Appeal is giving the final decisions in all matters concerning military issues. That leaves a space in the law, a lacuna in the law, because people expect the Supreme Court to always come out and solve cases which, at least let it act like a space for justice. The Supreme Court, we expect those judges to come out and defend people who are aggrieved. But now if you are in the Supreme Court and you say, now for us matters coming from the Court Martial Court of Appeal, we don't know them, we can't handle them. First of all, you know, the Court Martial is having limited number of people who have known the law, when justice can be served basing on the law, not normal reason. Now, if you give room to the Court Martial and Court Martial Court of Appeal, which rarely even sits, to be the final court to give decisions on life matters, on very dangerous cases, it is so unjust for everyone and for people. Because the reason why we are looking at the Kabziguruka case, because at least can give, because originally the Court of Appeal had ruled on that matter, saying all civilian files should be transferred back to the civilian courts from the court martial, because civilians have been tortured in that court because of the limited number of people who know the law in those courts. So the mere fact that the Kabziguruka case had settled that, and the Attorney General appeals to the Supreme Court, which states the decision, has put people's lives at risk, not only for the civilians, but for everyone. Even if you may think, now for me, I'm not going to be facing that law, you never know when it can come to you. You can never know when you'll be affected by that law. So for us, we are praying that by 31st, let the Supreme Court do what it has to do. The whole world is looking at them. Everyone is looking at them, because this is the time Justice Owiny Dolo, Chief Justice, has to come out and show the world whether he's working for the people or he's working against the people. Well, at least with this decision, we are sure for someone who wants justice, this is the only time you can show us that indeed you love people. Because you cannot tell us that now you are saying civilians should be tried in military courts. We have seen civilians suffering in military courts. We have seen advocates suffering in military courts. You can't even submit well. There's a lot of intimidation, a lot of security, there's no fair hearing in that court. So our prayer is the Supreme Court, the judges there, please handle the case well. Please bring justice. We need justice. The reason why we started law is to promote justice, and we expect that from the Supreme Court comes 31st. Yeah.
As we wait for that ruling of 31st, I want first of all thank Agora. They have been relentless in pushing the Supreme Court to give us this ruling. I want to applaud every human right and democracy, good governance activist who is out there. Because at least we have seen that our system only responds when people push. I've seen so many people criticizing activists, criticizing peaceful protest, and we are seeing it is working. The Supreme Court would never ever even set a date to give this ruling if it was not pushed. I'm really so grateful. Agora, that team of Agatha, you guys really did us great. It doesn't matter what the ruling will be. At least we will know what they think of about Ugandans. So, Owiny Dolo and the rest of the justices who will be there, they should remember what General Mugisha Muntu said, that when you're still in that position of influence, make sure that you set out environment that will favor you in the future when you're no longer in that office. I remember him telling one officer, that video is still there. So whatever you do, let us strive for fairness for everybody every day, because you never know what will happen to you when you leave that office. Let's wait for 31st January, and we see what the judiciary of Uganda has for Ugandans, whether they are independent and their function is to cater for justice for Ugandans. I think today we can pause it. Maybe you tell people your last words.
My last words is my emphasis is still on the Supreme Court, because by the time Aaron was arrested, that is something he was fighting for. Aaron has been in practice for over 14 years. Aaron has been in court martial. He has been seeing people suffering. In court martial, he has had the cases there. Aaron has fought for human rights. You can't fight for human rights when you're always seeing people suffering in such courts, and you know what constitutes such courts. That Kabziguruka case is so important, just because the Court of Appeal had already ruled on it. The Attorney General appealed to the Supreme Court. The regional judges of the Supreme Court, over 3 of them are no longer in the Supreme Court, and they replaced. Some died off, some are in exile, and the current judges have a big role to play. They have a lot of work to do. They have to make thorough research on all points of law under that case. I'm asking the judges to also look at factual situations. Look at the number of people who have suffered in that court martial. Before you make your decision, look at how people are suffering in that court. Look at what constitutes that court. Look at the number of advocates who have suffered in that court. First of all, we saw Counsel Kwago suffering in that court just because of a mayor word he uttered during that time we had the pan of this officer that passed away. He made some small utterance, was punished severely. We have now seen Council Aaron punished severely beyond the maximum sentence he can even get in that court. We have seen political prisoners suffering in that court. People have been punished in that court for even matters beyond. So we are requesting all judges who are going to handle that case, please promote justice. Article 126 is very clear. It says courts are a house of justice. Equality must be considered in making decisions. Principles of equity. We all studied principles of equity. What constitutes equity? Whoever comes to equity must come with clean hands. Equity is equality. Please, as you make your decision, that Kabziguruka case, consider equity. Look at the people. Please save civilians from court martial. That's my final word. Thank you.
Not add anything.